different. Happy to have this be a collaborative learning experience. So, and then I will, about 9:15, about 10, 15 minutes from now, hopefully the DOR folks will be able to jump on and we can introduce them. They can give you kind of just a presentation of where they're at and what they're doing. And then we'll just do open for questions and answers and see if we can get everybody's questions dealt with. So without further ado, let me see if I can share my screen. Hey, can everybody see that? At least a thumbs up from Dan.
Yes, yes,
right.
we can see it. And I will just say real quick, if you do have questions, you can use the raise hand feature next to your name in the participant box, and that will give an indication for us to manage the question answers, and that we can have this dialogue between Kelly and the rest of you. So, sorry, go ahead, Kelly.
Perfect. I also mentioned that I went to UC Santa Cruz, so doesn't that also give me some, like, you know,
some street cred?
Some street cred. Thank you. That's the word I was looking for. All right. So first I wanted to start with a little history because it's been a turbulent road to get here, and it helps me understand kind of how we ended up in this situation. In 1970 is when the feds made marijuana and THC, the active ingredient in marijuana, Schedule I drugs, which means that they are federally regulated illegal drugs. In 2004, Montana voters passed that first medical marijuana bill, almost 62%. And that was the first place where we started dealing with medical marijuana. As probably most of you remember, there really wasn't any regulation at the state level about it. And we soon found ourselves in a situation with people walking around with AK-47s and marijuana. No, outside of Helena here, we had a huge marijuana facility that was had a pretty dangerous situation going on. So you'll probably remember the raids. There were lots of things happening. In the middle of all that, the legislature passes SB 423, which really cracked down on the use of medical marijuana in Montana. Most of those provisions were upheld by the Supreme Court in 2016. Because of what had happened there, the medical marijuana folks went back to the ballot and got another medical marijuana provision, a ballot passed by 57%, and removed most of those restrictive provisions. And that's kind of where we've been operating since. In 2018, the Farm Bill legalized the use of hemp. And so that's why you started to see hemp and CBD happen without any kind of federal ramifications. Those don't have THC, an active ingredient in them. And then in 2020, Montana voters passed I-190 legalizing recreational marijuana. To follow up on that, the legislature then put in some provisions, changed some of the language in I-190, and most importantly, changed the effective dates. And that's how we ended up being able to still be kind of figuring out what we're doing in the transition at this point. So that's the background. Quick overview of where we're at right now and how we've been dealing with just medical marijuana right now. All the licensing has been going through DPHHS. That's changing and going to DOR. DPHHS can deny the application if it's not in conformance with local building codes, essentially fire codes, can't be within 500 feet of the worship or school. And we had the authority, both counties and cities, to prohibit by a local ordinance or resolution. We could also regulate, but we also specifically could prohibit. Here's the language that allowed us to regulate and prohibit. And that, it turns out, is pretty much the exact same language that has been translated now into HB 701. So not a lot of language change in terms of what we're allowed to do under new law. The one thing I will point out, though, is that this language about prohibiting has been taken out. And although it's not entirely clear by the language, it appears to have been replaced with a voter rejection and approval process. So if you want to prohibit or you want to approve and you can't do, and you're not in that position now, you need to go to the voters to make that 100% change. Otherwise, you can regulate. Okay, so the first thing I just wanted to point out really quickly was that under HB 701 and I-190, possession of minor amounts of marijuana became legal as of last January 1st, 2021. So in terms of criminal actions and misdemeanor prosecutions, they have already changed as of this year. The big change, though, is going to occur beginning January 1st, 2022. And this is when all former medical marijuana licensees, that's the term used in the statute, and it's defined as those who applied for their license on or before November 3rd, 2020. So they might have already had their license, but they might have just applied for it. Those former medical marijuana licensees can begin to sell recreational marijuana in those counties where a majority of voters approved I-190 starting on January 1st, 2022. So we're talking about the folks that you already see in operation in your communities. They then have to get their new license under the new system with their first annual renewal date after January 1st, 2022. And then they'll have to show compliance with the new statutory requirements, of which there are some, and any local regulations that you have in effect as of January 1st, 2022. And then until for that first year and a half, from January 1st until July 1st of 2023, DOR will not be taking applications for selling recreational marijuana, cultivating recreational marijuana, or manufacturing products for recreational marijuana from any new applicants. So it's kind of a grandfathering period for all those existing ones to come into the new system, transition into the new system. And then beginning July 1st, 2023 is when someone who didn't have their license by November 3rd, or didn't have their application in for their license by November 3rd, 2020, be able to come in at that date. That to me is one of the places where I get a lot of questions. A lot of communities are telling me that we have folks coming in right now, establishing very quickly and saying they're going to start doing recreational marijuana. They're not going to be able to do that. They have to have had their application in as of the day recreational marijuana got voted in on November 3rd, 2020. Okay, a couple of grandfathering clauses in the statute. If you have a former medical marijuana licensee and they just want to continue to sell, cultivate, or manufacture for registered medical marijuana cardholders, that's what they were doing, and they want to just keep continuing to do that. They are grandfathered from your local regulations that you adopt after July 1st until their first license renewal date. They will be grandfathered under the state requirements and be able to continue to operate, but you can start to deal with them later on. And there's also grandfathering for outdoor cultivation, which is now entirely prohibited under the new statute. But if they were already doing outdoor cultivation on November 3rd, 2020, then they can continue that outdoor cultivation. They can't expand it, but they can continue it. And then after the transition to the new system ends, so we've dealt with all the former medical marijuana licensees, then the new applicants starting on July 1st, 2023, they all have to show compliance with your local regulations to obtain their new license. And then everybody who's renewing their existing license also has to show that. Okay. I think I already said July 1st. Maybe I'm repeating myself here. Oh, red counties. So Mayor Jones brought up her question about what do we do when we're a community who's in a county where people did not prove I-190. So the statute essentially changed I-190 to hinge on this question. And they identified that all those counties where I-190 passed are called green counties. And all counties where I-190 did not pass are called red counties. Now you can go, if your jurisdiction, either the county or a city within the county, you can go through the process to put the question back to your voters again. And I suspect as we start to move forward and maybe some communities make a lot of money off of this, we might see some other communities decide, oh, maybe we want to get in on this and put it to a vote. So you can do that, but you don't have to deal with it right away, because if you're a red county, they won't be able to do anything but continue to do what they're doing under their existing license. But local regulations apply. The only thing I would say is I wouldn't move forward now with a prohibition to stop an existing medical marijuana licensee. So a former medical marijuana licensee who has been a dispensary in your town, you didn't have a prohibition on them before, and now as a local government, you're going to put a prohibition on them. I think under the statute, that has to be done by a vote. Okay, so just quickly, so you have these, this is the map. I think because of this map is why they were termed red and green counties. But this gives you a sense of where it passed and where it didn't pass. I do know that Yellowstone, in Yellowstone, the city of Billings just put the question to its voters about doing recreational marijuana, and they voted no. So even though Yellowstone's a green county, Billings will be prohibited for recreational marijuana. So I'll just quickly go over the basics of the red and green counties. If it didn't pass in your county, it's not called recreational marijuana now. Under the new statute, it's called adult use marijuana. Adult use marijuana sales don't happen unless your residents vote to allow it. So I think, Mayor Jones, that gets to your issue. You have a city where you're in a red county, so you don't necessarily need to deal with it, at least immediately, unless you've got an existing former medical marijuana licensee that's causing trouble and you want to pass some local regulations to, you know, make sure that those impacts aren't felt on the surrounding community. Those are the kinds of local regulations that I think you can continue to adopt. I just wouldn't get rid of them without a vote. In county where I-190 passed, so green counties, that's that same language that you've always had. You can regulate, including but not limited to. Now, like I said, it took out the prohibition language, so I think you're limited to a vote of the people for that. But everything else is on the table, including zoning and all of the powers and authorities that you have for controlling use and the impacts of use within your jurisdictions through your zoning powers, and that's both cities and counties. And then if there's a desire to change it at the local level, either from an approval to a prohibition or a prohibition to an approval of any one of the categories of businesses, then the residents can petition you to put that on the ballot, or the governing body can place the resolution on the ballot. That's what happened in Billings. The city just put the resolution on the ballot. Here are the categories, so they've been broken out. So when someone goes to a vote, you can vote on any one of these. You can say, we just don't want to have manufacturers in our town. We don't want to have dispensaries in our town, but we want to have these other things. That you can put that specifically to the vote, or you can say, like I think Billings did, maybe Billings just did dispensaries. Dan, do you know? Or is someone from Billings on?
Kelly, I'm on. Bill Cole here.
Hi.
Sorry, I just joined.
That's okay. Did you guys, your resolution to ask the voters on recreational marijuana, was it just as to dispensaries?
Correct.
Okay.
dispensaries and recreation adult use only.
Great, thanks, Mayor. So you can see, you can kind of pick and choose here what you want to ask your voters to prohibit or to approve if you're in a red county. So essentially your options for local regulation are kind of the same as they were before, except with this new voting process. So if you want to prohibit something entirely, you want to look to that voting process. But otherwise, you can use your zoning or your other ordinance powers, your business license powers, your marijuana, your ordinance powers to regulate time, place, manner, and the impacts really, because that's the issue, right? Is can we regulate them in a way so as they're not having a negative impact on the community or an area of the community? That's an authority you still have. The big issue is whether or not you can get those in place by January 1st. And if you can't, just know that it's limited in who it applies to during the transition period, but you can still get them in place to apply to the new ones that will be coming in on July 1st, 2023. I just wanted to point out that the statute does provide some preemption of local regulation because it has certain minimum requirements of every applicant. And so they have to meet these no matter what. So you really can't require less of them in these areas. You have to allow for the transportation of marijuana on public roads when someone has a marijuana transport license from the department. You can't reduce that statutory 500-foot spacing between the marijuana business and the worship or school, and there's a long list of what falls under those two categories. But you can make it greater. You can't impose new regulations on those ones that don't apply for licensure. They want to keep doing medical marijuana until they get to their first license renewal date. They're just going to continue to do what they're doing. They're not going to start selling marijuana or recreational use on January 1st. You can't start restricting them until you get to their first renewal date. Marijuana businesses, oh, sorry, I meant to update this to reflect what happened in a separate bill, but marijuana businesses can advertise in electronic medium, but they can't advertise outside of that. They can advertise their business. It's a matter of whether or not they can advertise using the terms marijuana products and using any kind of colloquial terms associated with that. And I'll go into that a little bit with the rules. And then of course, DOR can impose more state level requirements through rulemaking. And so I'll touch a little bit on what we have seen so far from DOR, and then we can introduce DOR and let them speak a little bit. In the summer, the first set of rules came out from DOR. Medical, they're mostly associated with registry updates. So those people who are registered card holders with DPHHS for medical marijuana, fixing some of the language in there and cross references that needed to be fixed now that the law was moving into a new area and that DOR was taking over. I don't see anything in there of concern. Those were adopted on August 31st. I've given you the rule number there, publication, so you can go look at that if you want to. The next set came in the summer as well. These were adopted in September, dealing with advertising. It essentially reflects what the statute says, that the businesses cannot market marijuana or marijuana products except in electronic advertising, so anything online. They have to comply with local sign regulations. Really happy to see that, just basic language, just referring it back to us. And then it prohibits billboards entirely for them to use. And then definitions and licensing. This is kind of the bulk of the rules that deal with what they have to do to get their license in this transition period. That hearing for these rules is coming up on 11/16 and comments are due on 11/29. I have asked my folks to let me know if you have concerns for us to include in our comments. But the two major ones that I think both VACO and the league have identified is whether or not we can get some more specific language in these rules that applicants have to comply with local regulations. There is that language in the advertising rules that I just talked about, and there's also the same kind of language under the section in these rules for combined use license language. And so I'd like to see if DOR would be willing to put some of that language, sprinkle that language in the other places, so that folks just have that heads up, and don't start to think that what they get at the state level means that they're in compliance with local regulations. And then finally, Eric and I have walked through the issue of whether or not the regulations are more broadly grandfathering in some businesses that's provided in statute. And that really has to deal with the existing former medical marijuana licensees who are going to continue to just do marketing, selling, manufacturing, cultivation in the medical marijuana arena, and how that's going to work, and how long they're grandfathered, and whether or not they're grandfathered from local regulations. So that's an ongoing discussion that we're having with them, and I just need to make sure I understand kind of what they're thinking and how these regulations are going to apply. So those are kind of the two areas. There's two more sets of rules coming. They have been released. The hearing is going to be for these two on 11/30, and comments are both due on 12/6. Under the taxation and enforcement ones, which you'll probably want to take a look at, that first 42-1040, there's a process for notice of license suspension and revocation that goes to the applicant. It would be nice to see that notice go to local government, so that we know if someone's been suspended or their license has been revoked. And then there's a lot of language in there about how the taxation will work if you pass that local taxation. And in particular, I wanted to point out that if you do pass that tax, you need to notify revenue 90 days before the effective date, or those payments won't be required until the end of the following quarter. So you might miss a whole quarter if you miss that deadline. So just wanted to make sure that you saw that. And then finally, 1042 has some additional registry updates and cleanup. I didn't see anything in there either, but that goes at the same time for the hearing and comments as the taxation and enforcement one. So just a couple of notes to you. Follow the rulemaking deadlines. Comment on any concerns you have. Get local regulations in place by January 1st if you have to address any of your existing former medical marijuana licensees. They're going to start selling recreational on January 1st, 2022. So if you have any problems with that and you don't think your regulations are good enough to be dealing with that, you need to get those in place. And I wanted to point out, remember that you have the power for emergency ordinances under Title VII, and you do have the interim zoning ordinance powers. It's a little easier for cities than it is for counties, but you still do have that ability to address some of the immediate issues if you need to get those in place by January 1st. You have, under the statute, you have to send those adopted ordinances to revenue in order for them to make sure that someone is in compliance with local regs. And if you wouldn't mind sending them to me as well, so I can keep basically a big folder of everyone's ordinances, that would be great, because then I can send out samples and templates to folks. And then MACo and the league put together a jot form survey for you to fill out your contact information that we can send a big database to DOR at once. So it would be nice if we could, if you'd make sure you fill that out, and we'll get that to DOR, and then all of those people will learn and get information from DOR when anything is happening. Particularly finding out about an applicant coming in who and DOR wants to find out if they're in compliance with local regulations. We are working very closely with DOR to make sure that we have input and can provide them assistance and help on making that determination from the local government level, so that someone doesn't get a license and then turn around and try and hammer us locally over the head with it, that they're somehow vested, even if they're in violation of local regulation. All right, so I've been seeing a whole bunch of pop-ups on the chat, but I think what I'm going to do is let DOR folks kind of talk a little bit. I'll introduce them, and then let's just open it up to Q&A for everyone to be engaged in. Let me stop sharing. I can figure that out. There we go. All right, so the first person I want to introduce is Courtney Cosgrove, because I see she's on. So Courtney, why don't you go ahead, and then maybe you can identify who else you've got on. That would be great.
All right, thanks, Kelly. Good morning, everyone. My name is Courtney Cosgrove. I'm the attorney for the Cannabis Control Division. I joined DOR in July, and so a lot like you folks, I'm still learning a lot and getting my arms around House Bill 701, which is a bit of a monster. I was 9 years with the Department of Revenue at a previous time, so I'm not complete newbie. I appreciate Kelly and MACo putting this together. I think as we move forward, communication between the state and local governments is obviously going to be critical. Even if there are disagreements, I think it's important for everyone to know where we stand on certain of these interpretations and policy decisions that have been made. I believe that Kristen Barber, who is the division administrator for the Cannabis Control Division, is on here as well. So I'm just going to pause and see if she pops up here.
Barber, and I just echo Courtney's comments that we appreciate being invited to this discussion and invested in creating relationships with all of you. We believe in transparency. We also want to be very honest that this is a brand new program. We're all finding our way through it, and it's plausible mistakes will be made, but we're going to do our best to try to, mitigate those the best that we can. And if a policy decision needs to be communicated, and we need to walk through that because it's a little bit, there's some, I will be very candid that there's a lot of gray areas in House Bill 701 that isn't super clear, or they didn't quite tie off all of the different, they didn't quite align all of the dots. And so we've had to obviously do the best that we can to get this program up and running. If something's working for you, we want to know, but if something isn't, we also want to know, and we look forward to being partners with all of you.
That's all I had for opening remarks. Kelly, if you want to let us know some of these questions, I think we can field. Some I think are more for you or MACo folks.
Yeah, so thanks. First of all, I just really want to thank DOR for being so open and communicative with us. It has been a huge improvement from what we had before, and I just really appreciate that. And I know local governments really appreciate that. Dan, can you, I for some reason can't open my chat, and I'm sure it's just because I'm an idiot, but if you could help me read the questions.
That's a great excuse, Kelly. I appreciate that. Happy to help out. So we've got one question here about what if they want to expand into another location? And that was from Sandra. So I don't know if you want to give some context to that, Sandra. Is it for an existing? Yeah. So
it was a company that had a dispensary in Kalispell. They was wanting to expand that same operation in Roundup. That's what I was wanting to know about their licensing. Of course, our county is red, so I don't have to be concerned about it, but it may not go away. So I'm trying to be as informed as I can. So
it's an existing former medical marijuana license, and they want to open a new location in Roundup.
Yeah, that's what they wanted to do.
But it's a red county. Would they be able to do it?
No new locations in red counties. So we read the language of 1612-301 as allowing former medical marijuana licensees in red counties are limited to their existing premises. So a green county is not going to be able to expand into a red county. And a red county is not going to be able to expand their existing operations either.
and then if they want, let's pretend that the same dispensary who is an FMML wants to open up a new one in a green county, they can, but they have to go through the application process during this transition phase.
Correct.
Or I guess after. They're
Right.
not limited. Okay.
And we've got another question here, Kelly, is will these slides be available after the presentation?
No, these are extremely important slides, and I'm going to be charging $500 of every person that wants them. Dan, I think you said you'd be hosting them.
Yeah, we can host both the recording of this session as well as the slides if you'd like. We can put them both in the on our website. Yeah.
Perfect, and we will put them on our website as well, of course.
Another question here is in a green county is an ordinance that prohibits business from selling from substances. Okay, in a green county is an ordinance that prohibits businesses selling from substances prohibited by federal law still valid and enforceable. Does that make sense?
It makes sense to me, Courtney and Kristen. I don't know if you guys have encountered this as well, but during the whole medical marijuana business, and I don't know if the counties do this, but the cities for a very long time, some of them hundreds of years or 100 years, have had provisions in their ordinance that say that they cannot permit businesses that are in violation of federal law. And they have used that to essentially not allow any marijuana businesses because they're in violation of federal law.
So there are cities currently that have these ordinances in effect, and they are okay.
It's not necessarily an ordinance. It's really just something that's in their code. It's been in their code forever. And I'm not sure anyone could even tell you how it got there or why. My position has always been that that's not a very strong one on which to rely when you have zoning authority and you have the ability, particularly before you had the specific authority under state statute to prohibit them. So you take that instead or regulate them through zoning. Now that we're in a situation where the prohibition really, the statute really hinges on a vote, I would be really concerned about relying on an old code provision that says we can't let you engage in any business that's in violation of federal law because you have a state statute that says you can do it. I think if you are in a red county, it's not an issue. If you're in a green county, I think you should go through the process to have the voters vote on it.
Yeah, I don't have anything to add to that. That makes sense to me, Kelly.
I
see
think this
Jim.
next.
Sorry, who was that? Dan?
Well, I was just going to say there's another question, but Jim, you've got a question?
I just wanted to see, I'm going to pick on Jim Nugent because I always love to call on him these big picture issues about municipal operations. And I just wondered if he'd had any thoughts about this.
I agree with you, Kelly. I don't know why some communities did that. I think your analysis is correct.
Yay. I'm taking that to the bank.
You got the Nugent stamp of approval.
Right?
So we've got another question here, and I think it's in a similar genre. If your current ordinance has a term prohibited in it, will it need to be amended to reflect the current law? I think it's, again, kind of that Sanders question on that.
I think, sorry to keep jumping in here, but I think because you're in a red county, I don't think you need to worry about it. But if you were faced with the situation where that was going to change, I think that you need to move. Either you need to have your voters specifically, let's say Muscle County puts it to the voters and the Muscle County voters approve it. So you turn into a green county. But you wanted to see if your voters in Roundup still want to prohibit it. You could then put that to a vote of your voters to say, wait a minute, how about here in Roundup, do we want to allow it? And if they don't say no, then yes, I think you need to move to a more nuanced regulation through your zoning or your business licensing process to determine how you can mitigate the impacts of those businesses and not prohibit them by ordinance.
Okay, so we have another question. You ready for another one?
Sure.
Is there a list that can be obtained to see who is FMML legal at this time and their addresses?
So I'll jump in on this one. When the program was at DPHHS, this was not information that health would share. Under Title 50, we're pretty restricted with what we can share regarding licensees. It opens up a little more in House Bill 701, effective January 1. We are going to put this on our webpage so folks can hop on under our licensee list and see who is medical only and who can sell adult use. However, on Monday, in another call with Kelly and with Eric Bryson from MACo, they pointed out that probably the Constitution would trump the statute in terms of what we can share. I would say we're still considering that. I think that analysis is probably correct. And once we vet it through legal over here, it's a really long lawyerly way of saying, yeah, I think we can probably get you that information.
Another question, also, does a community or a county get notified prior to them getting licensed? And does the local community have any say?
Yeah, and so that was the purpose of the call on Monday with some local jurisdictions to figure out what is that communication process going to be. And that's the reason that Kelly is asking everyone to fill out that survey. So what we are still trying to define, but what we likely will happen is that we get an application for a license. We will have a contact in that local jurisdiction that we notify that their a business is seeking a license there, and we work with someone on the county commission or the planning board or whatever it is who vets it on their side and lets us know whether that location and license type would be legal where they're wanting to set up business.
Great. And another question then, in medical marijuana dispensaries.
Sorry, Dan, before you
Sure.
go on to the next question, I just wanted to add to what Courtney said. I know we're still having the conversations about what that is going to look like. And I think one of the things that we were suggesting was whether or not we could do something where it's kind of a provisional approval. Either we make something provisionally approved based on getting your state license, or the state license gets provisionally approved based on knowing that something is approved at the state or at the local level. So we're still just kind of talking about how that's going to look and how, what the process is and who goes first and kind of how that happens. So, but I'm feeling a lot better about how revenue is open to this discussion than the previous situation where we had no communication at all. So I think it's really good. Thanks, guys.
Yeah, and we feel good about it too. It helps to have that safety net. We don't want to go out and license someone and then find out there was an ordinance we didn't know about, or we're right next door to a school that, or, private school. That's not a great example, but maybe like an in-home type place where if we walk out and do a physical inspection, we're not going to know that business is there. So I think having more sets of eyes on it is going to be helpful for everyone.
Thanks,
So
Dan.
the next question is a question of clarification. A medical marijuana dispensary is only able to sell recreational marijuana if they began selling prior to November 3rd, 2020. Is this correct? And just wanted to clarify that.
Yeah.
Their application had to be in, right, Courtney?
Right,
By
application
November 3rd.
pending on or before November 3rd, 2020, and then also in a green county. Those folks will be able to sell rec January 1.
And is that the list that you guys are going to post on the website?
Yes.
Yes, yep, we'll distinguish between who is who is medical only and who can sell adult use.
Just to give you a ballpark number, because it's helpful, is right now we have 434 licensed dispensaries in the state. 383 will roll over into the adult use market. So that gives you an idea that about 80 to 100, and our numbers are changing, you know, all the time, just because there are still people who are adding additional dispensaries under their previous license. But there will be about 80 to 100 that remain medical only.
Okay. And any sense of how many are in operation now but didn't meet the November 3rd, 2020 deadline?
So I think that's where taking into obviously the Green County, Red County, we're just ballparking it with an approximation because we're still going through our database, and I'd love to tell you that we feel really confident with the data that we have. We think it's close, but we're finding out that there was a time frame under the Department of Health and Human Services where their licensing system went down for 9 months. And so all of those applications were processed in paper. And so we're making sure that the paper application matches the information in the system, but we have found some discrepancies. And so that's why I'm trying to not give you an exact number because I don't feel confident about it, but I would say somewhere around the ballpark of 80 to 85.
Are you ready for another question? Here's one. If we pass the local tax on adult use, what will the flow of funds look like? Will the DOR collect the tax and then remit it to the city and county?
Kristen, do you know the answer to that? I can point you to our rule notice 42-1040. There is a rule, a draft rule in that regarding the local option tax. This was put together by our business and income tax division, and I'm not as familiar with it, but I would direct you to new rule 13 in that package. And that might answer your question. I'm sorry, like I haven't looked much at the tax side of it.
I mean, I would say, yes, the department's intention will be we collect the tax and remit it back to the county. Our preference would be like, we don't want to break it down into all of the sub-jurisdictions underneath the county. That's too much work for the Department of Revenue, and that can be different in all 56 locations. And so our point would be that we collect it, we remit it to the county, and the county figures out where that money goes within its area. So.
And that's right. That was the distinction I couldn't remember, was that we're not going to break it down to the local jurisdictions.
No.
All right, so another question, we're ready. If a city does not permit any dispensaries or have any, do they get a portion of the excise tax revenue?
And are you asking sorry, Kelly, I was gonna say by excise tax, are you talking about the optional up to 3% local option sales tax, or are you talking about the money that comes through the general fund that is then like allocated back to local governments?
So yeah.
What do you think, Wright County? You have a clarification there? Well, let's assume it's if the.
Dan, this to me sounds like a question based on what was originally in I-190, and I would answer it first by saying that got changed in HB 701. The money is no longer there's not a statewide tax being placed on it that's being allocated to local governments. It goes basically to state allocations, except for one small grant program to law enforcement to like pay for dogs. Other than that, if you want a local allocation of tax dollars related to the impact or to deal with the impacts of marijuana or anything else for that matter, you have to put that to a vote of your own voters, and then it just stays local. So if you don't have any dispensaries, you wouldn't get any portion of that unless you put in for a grant for that law enforcement one that I mentioned.
And I would just direct folks to section 95 of House Bill 701. I think also talks about what happens with the local option excise tax revenue.
All All right, so another question here is it correct that MCA 1612-301 sub 7 sub A is being read to require that voters in a city located in a green county vote to prohibit recreational sales? Is a separate resolution question required for each category of activities?
Yes, I'm happy to take that.
Yeah.
I don't think it's 100% clear that you can't prohibit without a vote, but I think if you read 301 and the rest of the statute as a whole, I think it comes to the legal conclusion that you would need to take it to a vote of the people to prohibit entirely if you're in a green county. If you feel like taking that to court, then I think you are welcome to try it, but I think that's what is read, that's how you read it. I don't think you need to have a separate resolution on each category of activities unless you want people to vote separately on each category of activities, right? So if you want to ask them separately so that they would allow some adult use like cultivation but not dispensaries, then you would want to ask it separately. But if you just want to prohibit everything, I don't think you would need to do it separately. Hope that makes
And
sense.
Kelly, can I offer just a little bit of clarity? Just I'm hearing like adult use, cultivation and manufacturing. I want to make sure everyone knows that the dispensary is the point of sale for the public, whether you delineate between medical and adult use or recreational. At the cultivation site and at the manufacturing site, that is not separated out. They can't say that this part of their grow is just medical because that's not, they can't separate it out. So if you're going to allow for cultivation, it doesn't separate out the recreational side from medical. So it's everything. So I just want to make sure everyone understands that if you're going to prohibit those types of businesses, you don't have to call them out individually for those types of products.
Thanks. If that didn't answer that question, please jump back in the chat or raise your hand.
Yes. And another question here, is a daycare one of the prohibited businesses, or anyway, so you got schools and churches, is a daycare fall under one of those, school or church, or is it daycare?
It doesn't, and I can't point to the precise section in House Bill 701 that has the 500-foot requirement right now, but it references, I believe it's a Title 20 definition of schools, and that does not include daycares. I can find the.
Yeah, I'm looking forward to.
So churches are the 500-foot distance. So churches and schools, and then there's a definition that defines what is considered a school.
That's right.
Okay. Is there a definition for church?
I just lost you guys. All right, sorry. There's not a separately referenced definition of church, but the statutory language itself is broad. It's church or other place of worship, but it is building used exclusively as a church. So, and I am not clear on whether that exclusively language also applies to schools. So I'm kind of looking ahead at the homeschooler, and our interpretation would be no, a homeschooler would not get that 500-foot minimum.
All right, ready for another one?
Yeah.
Okay.
And I think Kristen will have to hop off here. I know she's got a 10 o'clock call. So Kristen, do you want to, I don't want to keep you. Do you want to say goodbye?
Sure. No, I mean, it's
be unsupervised.
Yeah, no, it's, I know you've got it. It's a pleasure, to have the opportunity to, I guess, meet you virtually, and we do look forward to working with you in the future. If your local jurisdictions are going to move forward and make changes, please feel free to reach out. We're happy to be partners in any way that we can. And I'm sure as this evolves, we will all find our footing beneath us at the same time together. So I wish you all good luck. And again, we're a resource and a partner where we can be. Thanks and have a good weekend.
Thanks, Kristen.
Thanks. All right, so another question here about marijuana dispensaries in another county may not deliver into communities with a red county. Is that correct?
They would be able to deliver to registered cardholders. But we have in rule that there are not going to be any like Uber weed type of deliveries to adult use consumers.
If a marijuana grow business operates within a city in a red county, could a local option tax apply to any sales it makes to other marijuana businesses outside of that county?
To other so there is no wholesale tax. If I'm understanding the question correctly, the local option tax is only at the point of sale to consumers. The way I read House Bill 701, the money goes 50% to the county and then 45% gets distributed among cities based on population. But if it's just a grow, yeah, there is no wholesale tax. Not now. We think that may change in the next legislative session.
All right, I think that's it for the questions in the chat. I think we'll open it up. If anyone has any questions, if you want to unmute yourself, we'll take that risk. If you want to unmute yourself and ask your question, we've got just a few more minutes. If there's anything burning that you'd like to ask of our distinguished panel.
Looks like Mayor Cole has his hand raised.
Oh,
His
Mayor Cole, go
actual
ahead.
Physical hand, not
Go
the.
ahead.
Hey, Dan, thank you. Courtney, Tristan, Kelly, everyone, very helpful. I'm glad this has been recorded. This isn't really a question, but more just a comment. My prediction is that much of this discussion will trend to the issue of potency. And Billings was going down the path of looking very seriously at regulation of potency before our vote prohibited recreational use dispensaries. I would predict that that will be a big issue before the next legislative session, because that's what really matters. Marijuana has evolved dramatically since the 1970s, when typical concentrations were 2 to maybe 4% THC. Now your typical plant is well into the teens. State statute regulates at 35%. But the real issue are distillates and concentrates. In Colorado now, by sales, most sale of THC products is in concentrates and distillates. So you now can get a syringe with virtually pure THC and put a couple drops underneath your tongue. Creates real risks for aggravation of psychosis and aggravation of other mental conditions. That's pretty clear in the medical literature. And our state legislation is very inadequate on that. There's almost no models in the country. Vermont a little bit. So I just encourage everybody to start paying close attention to that. If people would like references to some of the information in the literature out there, you contact our deputy city attorney, Karen Tracy, and she can provide that. So just alert, that's a big issue.
Thanks, Mayor Cole, for sharing those thoughts. That's helpful. Any other thoughts or comments? Or questions?
Well, I mean, it's literally 10 a.m., so I can't imagine holding a more organized and timely meeting than that.
Yeah. So we're gonna have to put that in the record book. Well, I just do want to say thank you to our distinguished panel and their to Kelly and to Courtney for your wisdom and your thoughts and the clarifications you brought to this issue. So our appreciation to you for that. And then for everyone, again, this has been recorded. Kelly is willing to share for a nominal fee of $500 per slide per person. But she will share the slides, and we will pair those with the presentation and put those on our website as well. So we appreciate your participation, and this is an ongoing conversation, and I'm sure we'll probably have more as time goes by. So I know with the league, we'll continue having a couple, I think, after the Thanksgiving break, we'll have another couple of, we'll co-host a couple more webinars like this, town hall meetings, topics to be determined, or do we know them right now? I think you know them now, don't you, Kelly, what the topics are?
Yeah, we're gonna do one on the infrastructure bill when
That's
we've
right.
been able to kind of like get a little bit more understanding under our belt and maybe get some folks from the National League of Cities on to help us understand how that's gonna work.
Yeah,
Because we're not busy enough with all the other avenues of things everyone's dealing with.
yeah. So watch for that. And with that, I appreciate your attendance and participation, and we hope you have a great Friday and a great weekend. Talk to you all soon.
Thank you.
Thanks.